Lordship, I'd like to mention item number 27.
Yes.
I'm on behalf of V. Jamo, the petitioner.
German.
Yes, Lordship.
When
Yes.
do you want?
Yes, German. To be listed after 2 weeks.
We are listing too many matters after 2 weeks actually. Let's put it in the second week of May or something.
Okay. Lordship.
On what ground?
The leading counsel is out of station.
Lord, can it be fixed on 3rd May? I am from respondents.
Okay.
Yes.
No objection.
No objection.
Your Das.
Mr. B.
Das. Mention has been made on behalf of the leading counsel, Mr. V. Jamo, that he is out of station, and accordingly the matter may be listed on another date. There's no objection from Mr. V. Das, learned counsel for the respondent. Accordingly, list the matter in the second week of May for hearing.
Yes. Your Honor, I beg to mention item number 11, 13, 14, 15, 16, and 17. Today, Your Honor, that this AB, that victim has filed IA. Therefore, this IA may be here with the main case.
Item 11,
11, 13, 14, 15, 16, and 17.
14, 15, 16, and 17.
Yes, Your Honor. Written objection has been filed by the victim.
So you want another date?
No. This IA may be here with this.
But along with that,
yes.
is it? Why is it here? So you want another date or you want it today?
Today itself.
Oh, then it's okay. It will come up automatically. You just call. Okay.
I love please.
Lordship, I beg to mention on criminal appeal, this appeal number 31, 2023. Apply for listing
Item?
tomorrow. For listing on criminal appeal. It's not listed today.
Oh, I'm listed.
Yes.
Okay.
So it will be taken up to be listed tomorrow, Your Lordship.
Okay. What's the urgency?
It is a long pending matter, Your Lordship. And the accused appellant is behind a bar. It's the matter of 2023.
Okay, we'll try.
My Ladyship, I beg to mention item number 9. The conducting counsel is out of station. Please adjourn this matter for 3 weeks. Consent has been taken from the opposite counsel.
Okay.
Item number
I think
9.
the matters may not reach now. We don't have much time. Item number 9. Learned counsel for the petitioner.
Respondent, my
Respondent,
Ladyship.
please for listing the matter on another date as the leading counsel is out of station. Yes, you have something to say?
No, I am for petitioner.
No objection. No?
No objection.
Petitioner has no objections to the prayer for adjournment. List the matter when?
After 4.
After 4 weeks.
After 4 weeks.
Interim may be continued, Milo.
Trip order, if any, may be continued till the next date.
Much obliged.
Much of it.
Your Lordship, I beg to mention item number 20. So, in regard to respondent number 2 and 3, it's still awaited. So, I may be allowed to take a step
Fresh
afresh.
steps.
Yes, Lordship.
Respondent number
Respondent number 2 and 3.
2 and 3.
Yes.
It is mentioned.
I'm for the petitioner side. I'm appearing mentioned on behalf of Titip Dara. He's out of
it's
station.
mentioned on behalf of the counsel for the petitioner, Titi Tara, that service on respondent number 2 and 3 is yet to be served. Accordingly, the petitioner prays that you may be allowed to take fresh steps on respondents number 2 and 3. Prayer is allowed. List the matter after 3 weeks.
Your Lordship, that interim is due, that may be
The
continued.
interim order passed earlier shall continue till the next date. Yes.
This civil revision petition has been filed, saying the execution case, number 02/2012, pending before the, Board of Deputy Commissioner, Christians.
Okay.
Lordship, the
Where is the impugn order?
page 26. This is execution petition.
Okay.
Lordship, in the execution petition, I am not the party. However, the order, this execution petition has been filed for execution of order passed in title appeal, 04 of 2010. Even in the title appeal, I am not the party. The appellant, has
Title appeal 4 of 2010. There also you're not a party.
I'm not the party, and that appeal has been filed against a Kabang decision of 25/03/2010. Even in the Kabang appeal, I'm not the party. But the property against which the execution has been filed is the property that belongs to me, and the land in question has been allotted to me in the year 2009.
2009.
Yes, and entire litigation has been initiated 2010. Nowhere I'm party, but the order is against my property. And I was completely unaware of this entire litigation. I came to know only when the service, someone was served upon me on
Or in the execution matter.
yes, in the execution matter on 05/01/2024.
5
05/01/2024.
2024.
And since general election was scheduled in the month of April, so there was no sitting of the deputy commissioner court was not sitting for 6 to 7 months. So there was no proceeding further after 25/01/2024. Again, in the month of September, I got another order, summon notice, wherein I was directed to appear before the deputy commissioner on 23rd/01/2024. In that summon, so I appeared before them, before the deputy commissioner on 19/01/07/2024. The order is at page 23.
So you appeared before the DC in the execution case.
Yes, because I was unaware of anything about the litigation, so I appeared before the, on receipt of this summon, I appeared before.
You are Lokmo Patum. Lokmo Patum, okay. 19/9/24.
19/9/24 was passed in my absence. On 23rd, I appeared. You're on page 23 is the notice.
Yes.
Notice
Notice, notice
is
was
my-
issued to you.
is my name. But
Yes.
then, Your Honor, interestingly, the parties are Srimati Opit Talo and Yaye Padma. But the summon notice has been served upon me.
Served upon you, yes.
And
Whereas it's not been served to this Yaye Padum.
yes, and subsequent to this notice, 19/09/24 is passed by Deputy Commissioner Pasigar, wherein 2 months below, down below, in view of the above facts,
Which page?
24.
Page 24. Yes.
In view of above facts, Srimati Opet Talo is ordered to 2 months rent from the said building. This building,
That is your building.
yeah, this building
This building is my building, which is situated, constructed in my land.
Hmm. If the parties present.
And page 26 is the appeal,
Hmm.
I'm sorry, execution petition filed by the opposite party here.
Oh, so you're not party.
Here also I'm not party. And page 33, this is the order against which this execution petition has been filed. 280720, page 33 is the type copy. Here also I'm not party. But then order is against me, against my property. But then
So this
there is
rent-
no amount mentioned here. Only
It just says 2 months rent.
no in this 2807/2021
Hmm.
2011 is the order against which this execution petition has been filed.
Mhm.
And in this order,
The title suit, this is the title appeal.
yes, right. Or this order has been passed in the title appeal. And against that order, execution petition has been filed. And even in this order, there is no mention of money.
The payment of the value of the building.
Only to
Okay.
assess the value of the building constructed in my land.
Hmm.
However, I am not party. And
You
subsequent
were
upon
not
this-
aware, you were not aware of this title appeal
Yes,
also?
I'm not aware. I'm not aware of.
Learned counsel, we such and such appearing for the petitioner in the present case. This instant revision petition has been filed, assailing the legality of execution case number 2 of 2012 pending before the learned DC Basikat. And the order dated 28/7/2011. And the order dated 19/9/24 passed in the execution case number 2 of 2012, by which the respondent number sole respondent, by which the sole respondent was ordered to collect 2 months rent from the building of the petitioner. Stop. It is stated that the present petitioner was not aware of the present petitioner was not a party in the execution case 2 of 2012, nor was he a party in the title appeal 4 of 2010, from which the execution case 2 of 2012 arose. Stop. It is stated that the building in question before the learned DC Pasikat or East Siang district. Learned DC, okay. Learned DC Pasikat belongs to him, as he was allotted the plot measuring around 380 square meters in the year 2009. And since then, the building/plot is in his possession. So, The petitioner has therefore prayed for quashing and setting aside of the impugned execution case number 2 of 2012 and also the order dated 28/7/2011 passed in title appeal 4 of 2010. So, next paragraph. Issue notice to the sole respondent, returnable within 4 weeks. The petitioner shall take steps by registered post with AD within a period of 3 days. You have an interim prayer.
Yes.
Where is it?
Page
Page 18. Till the next returnable date, the proceedings of the execution case number 2 of 2011 before the learned DC Pasikat shall remain state.
And Lordship, the operation of order 19/09000. Order passed in the
Wait. 19/9
1990.
and the operation of the order dated 19/9/2024 in the execution case 2 of 2012 is state till the next returnable date. Four weeks. Next returnable date.
Lordship, this petition has been filed on the basis of settlement. Lordship.
Settlement.
Yeah. We have settled the case. This is out of motor accident case.
Okay.
We have settled the as per the settlement, USA. As per the demand of the party, who has received injury, have here owned this medical expense, and thereafter we have settled the case. And
Where is it? Your,
this is a joint petition.
oh, okay.
Yeah, joint petition. Okay. We have already settled the matter.
But there must be some settlement agreement, isn't it?
This agreement is enclosed in the page number 40 is the operative portion.
40.
Yes, 39 is the annexed tree.
It's starting from page 38, Lordship.
Page 38.
Page 30
Oh.
is the annexed settlement, field of settlement come compromise. The page number 38, paragraph number 4 and 5. As per this agreement. In 4 and 5. He was a bike rider, and I was also a learner at that point of time. In the crossing point, there was a accident at Itanagar. That is why after accident, I all those. In terms of the Lakshmi Narayan matter, Lakshmi Narayan case of FS court decision, paraphrasing, there is some parameters have been set, saying that
Yes.
any civil nature case in the interest of party, such nature of cases.
And not only that, if the offense does not is private and not public.
Yes. Overwhelming is in civil nature. Petty offenses.
Of course, non-compoundable
Yes,
sections are also there. but-
Non-compoundable matter. If it is the compoundable matter.
Acha, yes, BP. Hey,
Lordship,
Vishen.
this is the TCI call for Lordship, since it matter is pending before the trial court. Lordship.
We'll try to dispose of on the next. Meeting. This is an application under section 528 of the BNSS 2023 for quashing and setting aside the FIR dated 3/5/2023 in Itanagar PS case number 96/2023 under section 279/337/338/427 IPC and the corresponding GR case number 293/2023 dated 30/5/2024 and charge sheet number 80/2024 dated 26/5/2024. So the petition is filed on the ground that there is a settlement compromise agreement dated 7th March 2025 in between the parties. And hence the prayer for quashing the aforementioned FIR. So, learned PP has accepted notice for the state respondents. Therefore, there's no need for issuing formal notice. Call for the LCR from the court of, which court?
JMFC.
From the court of JMFC, West Siang District. So list the matter on receipt of scanned copies of the LCR.
There is an interim order that, that interim order may be passed, saying that the further proceeding of the case may be.
In the interim, further proceedings in the case shall remain suspended till the next date.
Please, Your Lordship. Lordship, I'm appearing on behalf of the petitioner, Srimati Abida Begum,
Mm.
who is the duly authorized sister of the accused persons, Asadin Ali, who is currently in judicial custody. Here in this case, Lordship, this petition is filed for quashing the non-bailable warrant of arrest, which was issued on 9th January 2025 by the special judge UPR. Here in this case, Your Lordship, the accused was already granted regular bail
Mm.
on 30 October 2024, Your Lordship. Despite of this, NPW was issued without cancellation of the bail order and without giving the accused or his surety to any prior notice or opportunity to pardon. So in this connection, so what happened in this case, Your Lordship, I'm come to the brief of the case, Your Lordship.
Mm.
The charge sheet was filed on 31st of May 2023, Your Lordship. And the Honorable Session Judge took a cognizance in this case and issued a notice to the accused persons. Thereafter, Lordship, on last occasion, the last matter was listed on CC for CCA, but the accused could not be appear on that day because of the severe stomach pain and fever, Your Lordship. And we have submitted the documents of the medical prescription. But despite of this, this Honorable Session Judge has directed him to appear on the next day, that is on 9th January 2025. Because of the due to the deteriorating health condition of the accused, we could not establish communication with the accused persons regarding the death. So because of that, this Honorable Court led issue non-bailable warrant of arrest against the accused persons. So
Did you approach the learned
yes,
court
yes,
below?
yes,
to cancel?
upon fully recovery from the illness, Your Lordship, the accused acted responsibly and promptly filed one criminal mix application on 18 February 2025, Your Lordship, for recalling the NPWA, Your Lordship. But what happened in this case, Lordship, the Honorable Session Judge has found that the document which has been furnished before the Honorable Session Judge is nothing understandable. So therefore, he is rejected our application. In this case, Your Lordship, the accused has no intention of evading the law, evading the judicial process. He was genuinely ill on that day, Your Lordship. So the main issue regarding this case is the legality of issuing the non-bailable warrant of arrest against the accused person. Because here the Honorable Court did not cancel the bail order. And further, he did not even give an opportunity to hear to the party, which the basic principle of the natural justice is violated in this case, Your Lordship, which the doctrine principle says, Your Lordship, oti alteram partem, which means that the right to be heard by the other party. Your Lordship.
No, see, bail was granted on 30/10. So normally the court fixes a date, keeps on fixing dates. And when you don't appear, when the accused doesn't appear, then we issue warrant. I mean, that's what normally the courts do. So no need to, cancel the bail or anything, but that is taken as a violation of the bail condition. Because the bail condition says that you have to appear as and when the court summons you. But if you don't appear, then warrant is issued.
Your Lordship, our intention was not to have it the judicial process, but
You have the
due to the
records.
medical
Yes,
reason.
my lord.
Yes.
Yes, Your Lordship. This issue has come before this honorable court earlier also, Your Lordship. Now, Your Lordship is correct.
Same person.
To the extent, not same person, Your Lordship. There was an issue regarding the procedure part that
Oh,
if the bail order is prevailing, without cancelling the same, whether the bail can be cancelled or not. The bail cancellation, if we pointed the term bail cancellation, then we directly go to section 439 and 437 of the CRPC. But Your Lordship, in these kind of cases, Your Lordship, the cancellation of bail comes when bond is cancelled. If the bail bond is cancelled, then automatically, Your Lordship, it's a cancellation of bail. It's same effect. For that, prior to issuance of NBW, the learned court below must given an opportunity where, Your Lordship, in the case also, Your Lordship, there are case laws are there, where he says that natural justice will also follow. And secondly, Your Lordship, whether it was a deliberate, voluntarily one or one, it was voluntarily violated or not, that has to be taken into consideration, not in a mechanical manner. So, Your Lordship, to that effect, Your Lordship, the judgment with this, our Honorable High Court judgment is also there, but there also, Your Lordship, we have placed this judgment. Here, Your Lordship, will directly come to the impugn order part, Your Lordship. Page number 41, Your Lordship. May I read, Your Lordship? Present case speaks for appearance, production of the accused person and for hearing on charges. Accused Asadul Ali is absent. This is the present applicant. Accused Srimati Mofida Begum is present along with the learned PDC. Sri so and so is represented by special PP and NDPS. Present case was fixed yesterday for appearance of the accused person, namely Asadul Ali and Mofida Begum, and hearing on charge, whereas accused Asadul Ali remain absent. Petition number 1025 was filed by Advocate T. Tajum Game, stating that the accused Asadul Ali is suffering from fever and he is visiting doctor at Lalu. It is observed from the record that the present case was fixed for consideration of charge since 18 so and so, and thereafter on 10 dates the case was fixed for hearing on charges, but the charge hearing could not be taken place due to absence of accused person on different dates showing different ground. Hence, this case is fixed today for hearing on charge and the accused person were directed to be personally present today. Though accused person, namely Mofida Begum, is present, but accused Asidul Ali is found absent without any step. It is submitted, Learned Counsel C. Peter appearing for the accused, that accused Asidul Ali could not be contacted. Issue NBW against the Asidul Ali with a notice to the bailer, namely so and so, with a expediting the arrest. Next date is fixed on so and so. Now, here, Your Lordship, there is no any order of cancellation of the bond. Because it is well settled, Your Lordship, that once bail bond is cancelled, then later on, Your Lordship, NBW can be issued. If bail bond is not cancelled, Your Lordship.
There is no mention of.
Yes, if bail bond is not cancelled, that means the bail order is prevailing. And if the bail order is prevailing, NBW cannot be issued, Your Lordship. This is the procedure, says, Your Lordship. And which has been, Your Lordship, highlighted in many cases now. So far as natural justice is concerned, that will come on the later part. But here, Your Lordship, from the record, it also shows that the accused was represented by the counsel and informed the court that he was not well. So that is one of the aspects, Your Lordship, which the learned trial court has
ignored, your lordship. After your lordship, cancellation of the bond, no doubt NBW can be issued. And moreover, your lordship, it is also settled that, your lordship, the bail it has been held by the Honorable Supreme Court, is bail is nothing but a surety. So if accused is not appear, then court should make an effort to
Surety,
issue
yes,
to
yes.
surety. And if surety fail to bring the accused, then court is well within its jurisdiction to cancel the bond and issue NBW, your lordship. This is the procedure. This is the actual procedure, your lordship. If your lordship allowed, then this are the citations, some citations. This is 2023 SCC online JNK 306. This is also relied in our own coordinate bench, your lordship. I will come to that on the later part. Now, your lordship, the paragraph 4 and 6. Paragraph 4, your lordship. High Court of Madras, in case titled Prabhakaran Petitioner versus State, represented by Inspector of Police, Lavinpadi Police Station, Erode, so and so, relied by Counsel for Petitioner, while considering the scope and import of Counsel for Petition, import of Section 446 of the Code of Criminal Procedure, in para 10 of the judgment at para 182 and 183 held as under. I regret I am unable to persuade myself to agree with the said view taken by Odisha High Court as well as the Delhi High Court, wherein the learned judges have taken the view that where there is a failure of the accused to appear before the court, no further inquiry or proof is necessary or contemplated for recording satisfaction. In my considered opinion, mere failure to appear before the court in absence of any willingness on the part of the accused would not amount to a breach. Manifestly, there has to be animus on the part of the accused not to abide by or comply with the terms and conditions of the bond. Such animus alone make the failure of the accused to appear a breach in terms of Section 446 of the Code. Such animus on the part of the accused could be ascertained only after affording sufficient opportunity to the accused. On receipt of the notice, if the accused satisfied the court that he was prevented from appearing before the court due to sufficient reason, the court may not record such satisfaction, holding that the accused has committed a breach of bond. The language proof to the satisfaction need to be underscored with clear doubt if any the term proof held within is disproved by accused. Now he says your accused surety also. Such proof or disproof of animus can be arrived at only after sufficient opportunity to the accused surety. Such opportunity shall satisfy the principle of natural justice, odi altram paltam, which is not alien to the criminal law, as it has the sanction of the Constitution of India. Therefore, before recording such satisfaction, notice to the accused is necessary and further inquiry should follow. On such inquiry only, the court has to get satisfied himself on proof as to whether there was any breach of term of bond. And after so satisfied that the breach has taken place, then only such recording of satisfaction of the court will indicate breach of term bond. Now, your lordship may directly come to para 6, last page. Now, this judgment has been appreciated by the court, the Jammu and Kashmir High Court.
Para 6.
Para 6, yes, last, your lordship. The ratio of the judgment of Prabhakaran and Narata Ram Supra make the legal position manifestly clear that before recording such satisfaction that breach has been committed, the court is required to issue notice, and after affording opportunity to offer any explanation, if the court is not satisfied with the said explanation offered by the accused, then the court has to record such satisfaction that the term of the bond has been breached, which alone signifies the forfeiture of the bond. Ratio of the judgment supra is squarely applied to the fact of the case in hand. In the case in hand, it is apt to reiterate here that impugn order that is so and so rendered by the Court of Session Judge Samba does not signify that the provision of Section 446 has been complied with full rigor, and the court has recorded the ground of such proof in regard to forfeiture of the surety, bond surety to pay the penalty of rupees so and so, or show cause why the penalty should not be paid by the accused, as no notice to the accused before forfeiture of the bond has been issued. Thereby, a principle of natural justice has been violated. That much, your lordship. Here, your lordship, no opportunity has been granted, your lordship, and the bond amount was forfeited, and later on, your lordship, the penalty has been imposed, and they have challenged that impugn order, your lordship.
But in this case, the bond was not forfeited, no?
Yes, your lordship.
Surety also was not summoned.
And here, your lordship, in our on High Court, Your Lordship. All this judgment has been considered, Your Lordship, which is reported in 2024 Supreme Guwahati 1772, Your Lordship. I will only, Your Lordship, go to the judgment which has been relied, Your Lordship. Considering that, Your Lordship, the order of the learned trial court was interfered by our coordinate bench, Your Lordship, para 20, directly come to para 20, Your Lordship. 20 and 21, Your Lordship. Mr. So-and-so fairly submit that in the instant case, the accused Sri Kamaluddin was granted bail by this court on so-and-so and was released on so-and-so with certain condition, and unless the said bail granted to the accused Kamaluddin is cancelled, he cannot be issued non-bailable warrant of arrest without giving notice to his bailer, much less the arrest of the accused unless the earlier bail is cancelled. So now in para 21, Your Lordship, the judgment which I have relied has reiterated in 20 Roman 1, now 20 Roman 2, Your Lordship, the another judgment, Your Lordship. 21 Roman 2, Your Lordship. Mahesh versus State of Kerala. Page number 5. May I read? Mahesh versus State of Kerala, 2009 SCC Online Kerala, so and so. The relevant paragraph are reproduced here and below. Section 446A deal with the cancellation of bail bond. A joint reading of section 439, 441 and section 446 of the code show that when a person is granted bail by the court or session court, he shall be released on bail only after execution of a bail bond. As provided under section 441 of the code, if any condition is imposed by the High Court or the Court of Session, such conditions shall be incorporated in the bail bond. If any of such condition is violated by the accused and thereby such bond is forfeited by any person or persons who execute the bail bond, bail bond shall stand cancelled by virtue of 446A of the code. The cancellation of bail bond under section 446A of the code is an automatic eventuality, and it is occur on account of breach of condition in the bail order and consequent forfeiture of the bail bond, section 446A of the code. Does not make any difference in the case of bail bond executed on the strength of bail order passed by the magistrate or High Court or Session Court. It applies equally to the bail bond executed either on the basis of the order passed by under section 437 or 439 of the code, and consequences under section 446A is same to such bond. If the bail bond is then cancelled under section 446A of the code as the consequences of violation of condition in the bail order, the magistrate is bound to proceed against the accused to procure his presence in court and also for forfeiture of bond. For this purpose, non-bailable warrant may be issued against him. If the accused is arrested and produced in the court, the magistrate may also commit him to the custody subjected to the provision of section 446A small b of the code. Therefore, it follows that if any condition in the bail order issued by the superior court is violated, the magistrate himself can independently proceed against the accused for procuring his presence or to proceed against him for forfeiture of bond. It may not be necessary for him to address High Court or Session Court to cancel bail. Section 446A is not controlled by section 437 subsection 5 or 439 subsection 2 of the code. 446A of the code deal with cancellation of bail bond, whereas 437 subsection 5 or 439 subsection 2 16 is invoked for cancellation of bail, cancellation of bail bond and cancellation of bail. Cancellation of bail bond takes, there is a difference between place automatically under section 5 or 446A of the code, whereas cancellation of bail is open order under section 5, 437 subsection 5 or 439 subsection 2 of the code. Under exceptional circumstances, in fact, there is no provision in the code which in express term deal with the power of the court to cancel bail. Neither in section 437 subsection 5 nor in section 439 subsection 2 of the code, the expression cancellation of bail is seen used. Going by the language of the code, what is contemplated under section 437 subsection 5 and 439 subsection 2 of the code is only issue of a direction to arrest and commit the accused to custody. But such power is often referred by the bench and the bar as cancellation of bail, and the said expression cancellation of bail is crystallized by its uses in various judicial pronouncement. However, before issuing a direction to arrest and commit to custody under section so and so, it is necessary for the court concerned to cancel the bail, and this may be reason why reference is made in precedent as cancellation of bail. To cancel the bail under section 437 or 439 of the code, very cogent and overwhelming reason are to be stated. The court shall not cancel bail in a routine manner. Under subsection 437 and 439 of the code, as per the law, this is a settled position of law, but the position under section 446A of the code is totally different. If the magistrate court is satisfied that there is a breach of condition of the bail bond and thereby forfeiture of the bond automatically is then cancelled under 446A of the code. However, a mere violation of condition in the bail order will not lead to a automatic cancellation of bail bond under section 446A of the code. Apart from violation of the condition in the bail order, the court must also be satisfied that the bond is forfeited. Then alone, bail bond would stand cancelled and the accused can be proceeded against. It is the forfeiture of the bail bond which is crucial under section 446A of the code. If the breach of condition is not willful and is due to reason beyond his control, it cannot be said that there is a forfeiture of bond. The question is dealt with Rajan versus State of Kerala reported in so and so, and it is held thus. A bond for appearance can be stated to be forfeited only if there is a willful default on the part of the accused in not appearing before the court. It is needless to say that the accused can be absent in court due to various reasons on a particular occasion. When the counsel files in application, it follows that the accused was vigilant. Now this will follow in this case. And he had taken steps to instruct his counsel to file an application. Such an accused cannot be said to have forfeited the bond by reason of any willful default. It is only in case where there is a willful default on the part of the accused to appear in the court, forfeiture of bond will follow and penalty will occur. In the State of Kerala versus Anil Kumar, reported in so and so, referring to cancellation of bail, this court held thus: an innocent violation of any condition imposed by the court will not ipso facto lead to cancellation of bail under section 439 to CRPC. The crucial and vital question is whether there has been deliberate, contumacious and unjustified infraction of the condition imposed by the court. It is needless to say that if the court cannot cancel bail, if the violation of condition is not willful or deliberate, it is only reasonable to hold that such violation which is not willful or intentional shall not lead to an automatic cancellation of bail bond under section 446A of the code. It must also be borne in mind that whether bail bond is then cancelled under 446A or bail is cancelled under 437 or 439, the consequences which the accused may face are more or less same. He may be arrested and committed to jail. Therefore, the court shall be extremely cautious and careful while proceeding against the accused on the ground that the bail bond is then cancelled. To sum up, I hold that if the magistrate come across with instances of violation of condition of bail, or if a report is filed by the investigation officer before the magistrate court pointing out violation of the condition of bail granted by Superior Court, without there being any request for cancellation of bail, nothing prevents the magistrate from proceeding against the accused under appropriate provision of law, as indicated above. Nothing in the code prohibits the magistrate from proceeding against the accused if the bail bond executed on the strength of the order issued by the High Court or the Session Court is then cancelled under section 446A of the code. It is not even necessary for the magistrate to address the High Court or the Session Court to cancel the bail. However, if mere is an application for cancellation of bail granted by the High Court or Court of Session, the position will be different and the magistrate court will have to proceed as per the settled legal position. Now coming to the fact, I find that the High Court passed a bail order in favor of third accused and he executed bail bond under section 441 of the code before magistrate court. Thereafter, he released on bail by magistrate before magistrate court. If in any violation of the condition is the bail order, there may be a breach of bond and forfeit of the bond. In Bounty Mishra versus State of so and so, the 11th paragraph reproduced herein below. The court has gone through the order dated so and so and find that on that date, the petitioner were in attendance under section 317 of the CRPC. However, the learned court has directed for issuance of NBW and there is no order for bail bond cancellation. However, in the margin of the said order, it is mentioned that the bail is cancelled. It appears that in absence of any order of the learned court that the said act is done with is not in accordance with the law, the learned revision court has also affirmed the said order. In view of the above, the order dated so and so passed by the learned Chief Judicial Magistrate Diogar as well as the order of the learned revisional court dated so and so passed in criminal revision so and so in connection with so and so pending in the court of learned magistrate is set aside. The prayer made in ISO and so for additional prayer for main quashing application in para with regard to quashing of the order that passed by the learned session judge Diogar, whereby the revision prepared by the petitioner against the order that has been rejected is accordingly allowed and disposed of. It is made clear that if the petitioner failed to appear on the said date fixed by this court before the learned court concerned, the learned court will proceed in the matter and take coercive measure against the petitioner, Your Lordship. Considering, Your Lordship, this all this judgment, Your Lordship, the
Okay,
coordinate bench of this
got
court.
the point.
Yes, sir.
Since learned PP has argued so well for you,
Yes, Your Honor.
but was any notice issued to your surety?
No, Not yet.
No notice issued to the
Yes.
surety also. This is an application under section 528 and 483 of the BNSS 2023, praying for quashing the non-bailable warrant of arrest issued on 9/1/2025 by the learned session judge NDPS, learned special judge NDPS UPIA in NDPS case number 20/2023, arising out of Nirjuli PS case number 91/2022 under sections 21 small b under bracket /27 small a under bracket /27/29 of the NDPS Act. So, learned counsel for the petitioner, Sri such and such, has argued that in the aforementioned case, the accused / petitioner had been granted bail by the learned special judge NDPS UPIA on 30/10/2024. It is submitted that the accused / petitioner was appearing regularly before the learned trial court. However, on which date you could not appear?
On 9th,
However,
or 8th,
however,
8th January,
Mm.
8th January 2025. But again, matter was refixed on 9th of January.
9th, on 9th, NBW was issued, Your Lordship.
Anterior was.
no, but before that also, you didn't appear. Okay, anyway, that he had been appearing regularly. However, on a fixed date, the accused / petitioner was suffering from stomach pain and fever, and he had gone for medical treatment, and therefore he could not appear before the court. So, on 9/1/2025, the accused petitioner, through his counsel, filed a criminal misapplication being number 46 of 25, praying for recalling / cancellation of the NBWA stop. However, by order dated 9/1/2025, the application was rejected by the learned trial court on the ground that the medical document submitted by the accused was not legible. And thereafter, on the same day, the NBWA was issued against the accused / petitioner. The next paragraph. The learned counsel for the petitioner states that the accused was not responsible for the delay or for the absence, as he was genuinely under medical treatment. And it is also submitted that the accused person was not heard or the previous bail granted to him was not cancelled before the learned trial court issued the non-bailable warrant of arrest. So, It is also the contention of the learned counsel for the petitioner that without cancelling his earlier bail, the learned trial court could not have issued the non-bailable warrant against him, and therefore it is prayed that the said non-bailable warrant of arrest may be quashed and set aside. Learned counsel for the petitioner has also undertaken that the accused is ready and willing to appear before the learned trial court on a date fixed by this court. So, next paragraph. I have also read learned additional public prosecutor, Mr. T. Ete. This is so hard, no? T. Ete, who has fairly submitted that the said non-bailable warrant of arrest could not have been issued by the learned trial court without cancelling the bail bonds. He has relied on the case of Makhan Lal versus Union Territory of Jammu and Kashmir, reported in 2023 SEC Online JNK 306, wherein the Honorable Supreme Court has observed that a mere failure to appear before the court in the absence of any willingness on part of the accused would not amount to a breach of the bail conditions, and that there has to be animus, ANIMUS, animus on the part of the accused not to abide by or comply with the terms and conditions of the bond. Such animus alone makes the failure of the accused to appear a breach in terms of Section 446 of the CRPC. Stop. And such animus on the part of the accused can be ascertained only after affording sufficient opportunity to the accused. Stop. Burnett additional PP has also relied on a judgment of a coordinate bench of this court in Basiduddin versus State of Arunachal Pradesh, reported in 2024 GAU under bracket AP 1003. Wherein it was also held that a non-bailable warrant cannot be issued without prior conciliation of bail and due process, emphasizing the necessity of following legal procedures. Stop. Next part. After examining the records and after hearing the learned counsels for the parties, this court is of the view that the bail granted on 30/10/2024 by the learned trial court was not cancelled, nor was the surety given any notice before issuing the non-bailable warrant of arrest on 9/1/2025. So accordingly, the non-bailable warrant of arrest dated 9/1/2025 passed by the learned special judge NDPS UPI is quashed and set aside. The petitioner slash accused shall appear before the learned trial court on, when will you appear?
27 of this month.
27th is a Sunday.
Sunday.
28. On 28 April 2025. And if the accused slash petitioner fails to appear on the said date fixed by this court, the learned trial court is at liberty to proceed with the matter in accordance with law. With these observations, the petition is discussed.
And my lord, the earlier, he has to be allowed to be remain on the earlier bail bond, your lordship, because bail is not been cancelled yet.
Yes, so that remains.
Yes, yeah.
Here will lordship, same nature of case, lordship. NPW was issued by the honorable session judge, lordship.
This one also.
Yes.
Here,
This
it
is
is
other
not in the
cases.
custody.
What happened on that day, your lordship, NPW was issued because he was missed the court on that day, your lordship. And it was happened due to the genuine miscommunication regarding the date of the hearing, your lordship. And his counsel was stuck in traffic. Due to that, he could not able to inform the inform the court on time, your lordship. Thereby, this honorable court has issued the non-bailable warrant of arrest. Kindly see the page number
Impugn order is 70,
See
your
the
lordship.
impugn order,
70, your lordship.
70.
17.
Yes. Sir. Here, after issuing NBW, your lordship, notice was issued to the bailer.
I read, your lordship.
Wait. Yes.
On present case fixed for appearance of accused persons and for hearing on charge. The accused persons namely Baharuddin Rahman, Aminul Islam and Moizul Haq are present along with their learned counsel B. Mandal. However, the accused persons Sakir Ahmad and Sadiqul Islam are found absent without absence with steps stated by the PP. The peruse the record and seen that today is the fourth day fixed on the case for hearing on charges. However, the hearing on charges could not be taken up due to the absence of accused persons. It is observed from the record that on different occasions, different accused are found absent for hearing of the case. Due to that could not be proceeded. Issue NBW against the accused persons Sakir Ahmad and Sadiqul Islam with notice to the bailer. Here in this case, no cancellation of bond has been done by the honorable session judge.
Similar order. However, the impugn order date here will be 21/3/2024. And the name of the accused, obviously you see from the post title, okay? And then is next date of appearance, let it be on same day
Yes,
or 29th.
29.
29th. This next date of appearance may be on 29th, okay, before the learned trial. This one.
Not okay.
Compliance.
My lord, before entering into the merit of the case, this case has been listed in the admission stage. After traveling for the numbers of the years, because this is the case of 2018. Now
Yes,
this has been came back in the admission stage for the, my lord, final disposal of the case. In fact, what had happened, my lord, the respondent number, private respondent number 1 and 2 is the informant and the victim. And accordingly, while this revision petition is filed, they have been made as the respondent number 1 and 2. Therefore, as per the requirement, step was taken through the justice service. Thereafter also, despite of the criminal case, this court has allowed me to take on the justice service. Justice service was also taken, and for the third time, with the help of the concerned police station, that step was taken. And finally, on the last occasion, the court has found that since the non-appearance of the private respondent number 1 and 2 is intentional and they are not ready to contest the case, and in such situation, the case can be disposed of only by being represented by the PP of the state. Because
where
as-
is that order? Date,
Your Honors may kindly see in the last order on 8 January 2025. After this particular order, that whatsoever I have stated is pertaining to the
8 January.
Yes, 8 January 25.
Seen from this notice. Your notice on 2 and 3 deemed complete.
Therefore, my lord, at the outset, my prayer is that endeavors to dispose of the
Lordship,
matter today,
since-
if the PP ready.
This is a criminal revision petition. So amicus may be appointed.
We call for. On the 3.
Amicus may be
Ah,
appointed.
yes. Judicial magistrate, Chief Judicial Magistrate UPN, na?
Yes.
It is admitted, otherwise there is
Yes,
an
it's
order
already-
admitting the petition. If it's admitted, then it should go for hearing now. Then why it's coming admission then? We'll call for the LCR and list it for hearing, okay?
Yes,
Mm.
see, trial court I got already,
Because 8/1/25, order says admit the petition and list for hearing after 3 weeks. So it should actually come up in the hearing list, isn't it?
It should be there.
Yes. Yes, please read. Office note dated 8/1, no, not office note, order dated 8/1/2025 of this court has directed to admit the petition and list the matter for hearing after 3 weeks. And notice on respondent 2 and 3 is deemed to be completed. So, however, the petition has come up in the admission list. Trial court has come, a trial court record has come. Maybe it has come already. No. Oh, it has already come.
Yes.
Yes. However, what
Yes.
did I say?
Since respondent number 2 and 3 is not represented by any lordship, so one amicus may be
Amicus.
appointed. Yes, lordship.
No, no, yeah, wait. Let us first fix the date. However, that come in the admission matter, admission list, stop. The trial court records have also reached. And accordingly, the matter may be listed for hearing when? After 2 weeks,
after
may be listed for hearing, yes, in the hearing list after 2 weeks. So, in the meantime, the registry is also directed to appoint legal aid counsel.
My lord, pertaining to the amicus curiae is concerned, this is the matter involving punishment involving for 2 years only. So in case of such a petimeter, whether this amicus curiae is necessary or not. What, so for the
At least legal aid counsel.
yes,
should be there.
cardinal principles of the criminal cases that amicus curiae is required, but this is pertaining to only 2 years imprisonment.
No, but at least let legal aid counsel
Legal aid.
represent them, no? Which is directed to appoint the legal aid counsel for the respondents number 1 and 2. And copies of the appeal petition, the revision petition, this is revision, no? Revision petition may be supplied to the said legal aid counsel by the petition. What did I say? After 3 weeks, no? 3 weeks. This them 2 weeks.
Yeah.
For hearing after 2 weeks.
Oh, right.
Yeah, please, Lordship. Lordship, I'm appearing on behalf of S. Style, Lordship. Conducting counsel for the respondent, Lordship. Due to some personal difficulties, he could not appear today, Lordship. So this matter may be adjourned for today, Lordship.
For today.
Yes,
Today, after 2 weeks.
listed after 2 weeks.
Learned counsel for the, you are for the petitioner, no?
Yes, ma'am.
Counsel for the petition is present. Learned counsel for the respondent praised that the leading counsel, Taye is out of station, and accordingly praised for adjournment. List the matter after, let us put it after 3 weeks. List the matter after 3 weeks.
Deeply obliged.
My lord, I am for the
Yes.
appellant herein, my lord.
Okay.
Appeal against acquittal, Your Lordship.
My lord, in this matter,
Yes.
white order dated, my lord, 24/2/2025,
Mm.
then IA was filed along with the appeal, my lord, for praying to condone a delay of 195 days.
Okay.
The said matter was heard, my lord, on the 24/2/2025, and after the hearing, the learned court was, my lord, pleased to condone the delay. Appeal was admitted,
Mm.
and the trial court records were issued, my lord.
Called.
Were called
Trial
for.
court records called.
They were called for. The TCR was called for, my lord.
24/2/25.
My lord, on 24/2/2025.
For the trial court records. Okay, what about steps for notice upon the remaining respondents?
My
Will
lord,
be
all the
taken
my lord, we have done, all the respondents have been represented. There are 3 categories of respondent, my lord. One is the state, the learned PP is present. One is the private respondent being represented by my brother there. And the third are the Assam Rifle authorities, my lord,
Mhm.
because we have also put to challenge the procedure adopted in the trial.
Mm.
For that, my lord, the central government CGC has the DSGI had appeared, I believe, on one of the occasions.
So
But
everybody
it's an appeal against acquittal. Why they are required to be impleted? First of all, the
No,
person acquitted.
my lord, why they are required or not required, I believe the state will not be in a position to take that stand. It was the duty of the state to prefer this appeal at the first place. I am a victim over here.
Sorry,
And
brother.
why we have impleaded,
You-
my lord,
you-
No.
we are,
why
we are.
let me state why I have
No,
impleaded.
see, it's just that the court has given direction to take steps. That's why I'm just mentioning this.
My lord,
Court
And-
on 24/2 said the service of notice upon remaining respondents to be taken by registered post with
Sure.
ED as well as usual process.
My lord. And my lord, why we have implemented the central government authorities over here, there is a provision of law which is akin to section 125 of the Army Act, which says at the time when a cognizance is being taken, it is the duty of the court below to issue a notice and inform the commanding officer of the accused that if the institution so desires, they may take over the trial. It is a very settled position of law, my lord. We will bring it up at the time of trial. At this moment, my lord, if the trial court record has come, we can go for the formation of the paper book and then it can be posted for hearing, my
Yes.
lord.
It has come. Trial court record, or paper should also. Yes, trial court record is here.
My lord, direction may be given for
Yes,
preparation
yes,
of the paper books, my lord, and matter may be fixed for hearing.
So, CGC is also here,
No, CG is not present, Your Lordship.
not present, no? But he appeared on earlier occasion.
Your
There
Lordship,
was
on
an
earlier
occasion, my lord.
This is on 24/2, Your Lordship. There is an order from this court. The K Taja, my brother was appeared for respond number 1, and my learned sister appeared for the state, Your Lordship. And here, Your Lordship, trial court record was called for 234, Your Lordship, we have entered appearance. Appear, no, Your Lordship, the CGC has
No,
not appeared, Your Lordship.
No one appeared.
No one
On
appeared.
24/2 also no one appeared for 6 and 7. No, 5, 6 and 7. Previous day also no one appeared.
My lord, the service has been completed on the upon the central government authorities, my lord. But if the court is of the opinion, we will also effect a dusty service by hand service on the DSGI. And my lord, to
The previous
satisfy
orders
the
also nobody appeared.
Your Lordship,
Yes.
there's an IA for condonation of delay.
Uh,
So I think in that IA,
in that they appeared.
in some of the parties were struck off by this court.
Yes, Your Lordship. That IA number, Your Lordship,
I don't
if
have the
the IA
record
number
today.
is there, then we can find out, Your Lordship.
IA number.
IA for condonation of delay.
Already disposed of. but
It was already disposed.
My lord, IA number is 72 of 2024.
72 of 2024. Yes, it was disposed of. Yes, IA was
Exactly.
listed for many occasions, Your Lordship.
You put that one.
Acha, in the IA on 23/1/25, the court said that the respondents number 3, 4, 5, and 6 may not be a party for deciding the condonation application. Therefore, their names are directed to be struck out from the array of respondents.
My lord, that was only specific to the IA, where the private respondent was made the appropriate party for objection, if any, that was heard at length and it was disposed of, my lord. Thereby the delay was controlled.
Says for the condonation application.
My lord,
Yes.
23/1/25, the striking off was done.
Hmm.
And on 24/2/25, the delay was condoned, thereby admitting the connected appeal, my lord.
Okay, but today no one appears for 5, 6, and 7. That's why
My
you
lord.
take fresh steps again.
My lord, we may be permitted to take, we will deliver by hand on the DSGI, dusty service, my lord.
Your Lord, does the service not permissible under
No,
CRPC?
How can that be? Dusty service, how can that be? Service report, here it says 27/3, service report in respect of respondent number 6 has been received from
Only 6.
CGM. And the same is police report.
Only
It
6.
appears they have received on 6.
Only 6.
Respondent number 6 only. You take fresh steps by registered post on 5 and 7. Okay.
On 5 and 7, my lord.
5 and 7, yes. Six
My
is
lord, then
received.
I might as well take
Fine.
it on 6th also. They are the same authorities.
Okay, fine. Learned counsel for the appellant is present through VC. Learned additional PP is present for respondent number 2, 3, and 4. And you are for?
One,
One. And learned counsel,
K Taja,
okay, yeah, that's right.
Taja.
Appears for respondent number 1. It appears that service on respondent number 5, 6, and 7 is not complete. Accordingly, the appellant is directed to take first steps for notice on respondent number 5, 6, and 7 by a registered post with AD. Returnable within 3 weeks. The lower court records, the trial court records have been received. So the registry is accordingly directed to prepare the paper book and supply copies to the counsels for the parties. This is the matter of the 3 weeks.
In the meanwhile.
My lord,
Yes.
my lord, matter may be listed then for hearing after 6 weeks, my lord. We will
So
take
we'll
the steps
see.
in the middle.
We'll see whether the service is complete or not.
Your Lordship, in the meanwhile, I shall
My
be
lord.
filing reply if required. I mean,
Yes, parties may file reply if so required.
Yes. Obliged, Your Lordship.
Obliged, my lord.
May I please, my lord? My lord, in this case, on the last occasion, the CD was sought for. And by now, my lord, the CD must have come. It's a regular bail application.
Your Lordship, we have received the CD, but it's not a complete CD, Your Lordship. 161 is statement, nothing, seizure is nothing is the part of this case there, Your Lordship.
Oh, NDPS case.
Yes, Your Lordship.
Otherwise, my lord, I am totally on 2 counts, my lord. I'm under custody since last 88 days. And during the time of arrest, there was no any reasons of arrest or the grounds of arrest which has been given to me. There's a clear violation of Article 21 and 22, my lord, which entitles me for a bail. If they can justify that.
Commercial quantity.
Commercial, my lord. But during the time of arrest, my lord, the grounds of arrest has to be given to me. And that is the mandate of law. And to justify, to substantiate my submission, my lord, I can
For
take
that,
my.
we have to see the records. Then.
Further time may be granted, Your Lordship,
My lord-
because this was initially listed on 3rd, and not even a 1 week time has been granted to us, Your Lordship. That's the difficulty, Your Lordship.
This matter can be fixed on 11th, my lord. The PS is nearby only, my lord.
Which
And I've been under
PS?
detention for 88 days. Doimuk, my lord. It's just nearby. Hardly, my lord.
PP, is it
2
possible?
kilometers.
It's difficult, Your Lordship, and moreover, Your Lordship, the commercial quantity is involved. For investigation period, is, Your Lordship, is 180 days.
Yes, actually. it's
No, my lord,
180.
I'm
Yes, Your
not
Lordship.
that, my lord. If a grounds of arrest has not given to me in writing, my lord, that entitles me for a bail. There's a clear violation of Article 21. That detention itself is illegal.
Your Lordship, my brother submitting on the judgment where it has also been held by the honorable court that it has to be communicated orally also. Because in this kind of cases, Your Lordship, in this case.
Which I can try, my
For
lord.
that, I won't say anything now because. And whether such violations can be taken at the time of bail, that is also another
Yes, ma'am.
question.
It is there. And there's a judgment of our coordinate bench wherein the bail was granted, considering that aspect,
In commercial quantity.
commercial quantity, and under NDPS.
We'll see. Learned at the outset, Learned PP, additional PP has submitted that the charge, that the case diary is incomplete and he needs some more time to obtain a complete case diary. Accordingly, the prayer is allowed. This is the matter on
11th, my lord.
Maybe after break, Your Lordship. 11 not possible.
88 days, my lord. It's Doimuk
on
PS.
21st.
Okay.
On
It's too long, my lord. It's a
No,
regular bail
11th
application, my lord.
is my last day. I don't want to burden myself. 21st of April, 2025.
Obliged.
Obliged.
This is that anticipatory bail matter. Those series of cases.
yes, my lord. My lord,
This is item 11 to
Lordship, item number 11, 12, or 11 to 17 is arising out of same FIR, Lordship.
yes, yes.
But we received two separate CDs, Lordship. Item number 11, 12, 13. There's one
Separate.
separate CD and 13,
And
14, 15,
17.
yes. There's another CD.
But in compliance with the interim order dated 2/4/2025, the accused applicant appeared before the investigation officer for twice. My lord, that is on 3/4/2025 and 6/4/2025, and recorded his statement. And after that, my lord, he has executed a bail bond of rupees 30,000 before the IO.
Hmm.
Since my lord, the applicant-
Statement reported.
yes, already recorded.
Lordship, I make the Lordship. Close for Lordship. With regard to the item number 11, 12, and 13, Lordship.
This is 11, 12, and 13.
Yes, Lordship.
In item 11, 12, and 13.
Yes.
There is not much objection, only that certain conditions should be put.
Your Honor, I'm for the victim.
Lord, I am for item 13.
So 11, 12, and 13. Yeah.
Your Honor, that the victim has filed one written objection on this bail application.
No.
Yes, sir.
Okay, we'll hear you. In which one? In item?
All the items.
In all the items.
Yes, Your Honor. In here also, in this item number 11 also.
In 11 also.
Yes, Your Honor. In this item number 11, Your Honor, that the alleged accused was granted interim protection only on the ground that he has submitted one that the petrol that the gas refilling memo that he was not
there.
just that was the that refilling memo can be obtained by anywhere, Your Honor. But as per the statement,
But where is your application? It is not before the court.
this morning I have mentioned, Your Honor, and mention was allowed.
Yes, not completed. This is additional affidavit. It's not come, no?
Lord, I am for item 13. I have appeared before the IO on 3.
Wait, we'll
At
just come
3,
one by
3,
one.
3, I got bail, and 5th, I appeared before the IO. And I recorded my statement.
Yes, we'll go one by one.
Yes, Your Honor. Your Honor,
So, in 38 of 2025, 11. 11. Okay, in item 11, you appeared on?
Yes, I am for the
Yes,
applicant.
no, that's why you appeared on
My lord, two occasions on 3/4/2025 and
3/4/2025 and
6/4/2024.
6/4/2025.
And my lord, also the applicant executed a bail bond of 30,000.
Yes. and statement recorded.
Yes, madam. Already recorded.
Then item 13.
Item 13.
Uh,
I
you
appeared
appeared-
before the
appeared-
IO on 5th.
Appeared on 5th.
5th,
5th
and
April
also on 7th,
and 7th.
and also executed the bail bond of 30,000 as per direction of this honorable court.
Then in item 12, who's appearing?
I am.
Oh, you're appearing in 12 also. So there also you appeared
Yes,
on
appeared
3,
on
4 and
Six.
6, 4.
Yes.
So bail petition number 38 and 39. Huh?
But mine is bill 40, application number 40.
Yes, 40. So that means your only objection is that that memo could have been obtained from anywhere.
That can be, Your Honor.
Can be.
Your Honor, this case is the rarest of the rare case that happened in the state of Arunachal Pradesh. That more than 32 people they came to the spot where they all have came with local down and they have brought numbers of that gun. And from that gun, Your Honor, 6 family members, they were working at the agriculture field. They were shot down, and out of them, Your Honor, that the one person, 2 persons have been still admitted to ICU. They are struggling their life, Your Honor. And they are in that, while that, Your Honor, that the agriculture that they are performing, there was one woman also was there, and he was also beaten, he was also shot. And even, Your Honor, one that the bullet has touched at the head of the woman also, it's just scratch. However, Your Honor, that yes, one victim is there whose name is Taru. Still, he has been struggling for his life at ICU. He received multiple bullets, Your Honor, that I have annexed the.
See, the main intention is that the accused person should be available for the investigation, okay?
Yes, Your Honor.
That they should present
I
themselves.
may be given, Your Honor, just
Yes.
1 minute, Your Honor.
Okay.
That, and one person has lost both the leg because of the attack by the accused. And Your Honor, that in this item number 11, the accused person, he was the one who have come to the spot and he has come with 1 cartouche and he has fired here. And because of his firing, many have been injured. 6 people have been injured. Now, that the applicant is taking plea of ability that they were not present here, and they have submitted only one memo of refilling from the gas, Your Honor. But here many
And
witnesses are.
also, I think, check-in at the hotel or something like that.
That is in item number 13. That is in item.
Another case.
Yes, Your Honor. And Your Honor, just submitting one that memo refiling, if that would be the ground to receive the bill, Your Honor, in this case, the number of weapons has been used. Because of this interim protection, that none accused could be interrogated properly, and even that the weapon that has been used, that could not be seized. When I'm in interim protection, nothing could be happen, Your Honor. And this is the rarest of the rare case that happened in the state of Arunachal Pradesh. And
See,
even, Your Honor, that there was 6 people were there. And I have annexed the video clips also. That the victim's father, he was begging, don't shoot anybody. But from the jungle side and from the front side, that multiple firing were made. And because of that, Your Honor, 6 people, they are struggling for their life at dreams still, Your Honor. If they are released on this interim bail application, definitely, Your Honor, that there is a possible of hampering the investigation. And moreover, Your Honor,
we'll give stringent conditions.
Yes, madam.
And, see, court understands that it is a heinous and serious offense, okay, no doubt. But the only intention, bail is the rule, jail is objection, the things that you all know. So one thing which is in the mind of the court is that they have already appeared before the IO, and they have given their statement. So if they don't abscond and if they are willing to abide by the conditions, then.
and Your Honor, most important part is that this accused person, item number 11, he went to the spot with a covering with mask in his face, and he went here with police personal dress, and that was very serious, Your Honor. In this same case, that the victim, they have 2 months back, they have informed the police station also that these people are going to attack them. However, that the investigating authorities, they have not taken any steps. Because of that, Your Honor, that in this incident has happened. And 2 of them are, Your Honor, they are
See,
in
the
unconscious
IO
state.
is not seriously objecting. The IO says that they should not threaten or coerce the witnesses at any stage of investigation if they obtain the bail. So what more can the court do?
Your Honor,
Okay,
if
I'll
bail is,
record your
if bail
submission.
is granted, Your Honor, definitely that investigation is going to be hampered. And Your Honor, I beg to submit that in our tribal society, sometimes it's happened that if law is not taking its course in a good direction, sometimes it's happened that we go for revenge also. That is also a possibility is there, Your Honor.
No,
And-
that is outside the purview of this petition.
And only just bringing the refilling memo, if that would be a ground of.
No, that is not the only consideration.
Yes, Your
There are
Honor.
many other considerations are there.
With regard to the item number 11, 12, 13, I have no objection.
Yes, yes, that's right.
However, item number 14, 15, 16, 17,
Hmm.
the victim identified the person who
Acha,
accused,
acha.
In all case,
who should
11, 12, 13 also, Your Honor, victim has identified. Even that 11, 12,
so
13,
I
that
strongly
they
object
were, they were the one who have shoot
bail
the
application.
victims, Your Honor.
Okay, first go to item 11 again. This court had granted interim bail to the accused applicant, Shri Tagru Suraj, on 1/4/2025. The matter has come up for final hearing today. Learned PP has produced the case diary and the court has produced the same. Learned counsel for the petitioner states that after the interim order was passed on 1/4/2025, he has appeared before the IO on 3/4/2025 and 6/4/2025, and has executed the bail bond as directed by this court. So thereafter, his statement has been recorded by the IO on 3/4/2025 and 6/4/2025. So accordingly, it is stated that he has complied with the directions of this court and prays that the interim order may be made absolute and he may be allowed to go on bail. Stop. Learned PP has produced the case diary and he has drawn the attention of this court to the observation of the IO of the case, who has stated in his letter dated 8/4/2025 to the learned PP that the applicant who is presently on interim bail should not threaten or coerce the witnesses at any stage of investigation if they obtain the bail. Stop. It is also stated that the investigation is at an early stage and it is necessary to unearth the larger conspiracy of the offense. Stop. It is also stated that the investigation till date has not revealed the active role of the applicant and the direct applicant and he is not alleged to have directly fired the weapon, comma. However, the indirect involvement in conspiracy / abetment of the offense cannot be denied at this stage of investigation. Stop. Learned PP, therefore, has not objected to the bail application, provided that the court shall impose some stringent condition so that the applicant shall cooperate with the investigation. Stop. Next paragraph. In view of the above facts and observations and the statement of the IO, comma, the bail granted on, no, wait, before coming to that, the victim, but there are 3-4 of them, no victims also, it's not only one. So you are representing
victims.
all or all?
Yes. But that is affidavit
There are
filed by the
6.
informant. Yes, 6.
Learned counsel Sri such and such has made an appearance on behalf of 6 of the victims in this case, and he has filed an application, an IA. Has it come?
Number 30.
It's for 44. You give me for 38. Because he has one separate IAs and all the patients. No? So I'll just go through. Has filed IA 33 of 2025. And by filing the IA, he has opposed the prayer for bail, stating that the incident occurred on 26/3/2025, whereby 6 family members of the complainant have received serious injury by the gunfire and assault by sticks and machetes. It is stated that this inhuman act was committed by more than 32 persons with a pre-plan to murder all the family members of the informant. It is stated that the 6 injured victims were admitted to TRIMHS Naharlagun for further treatment. And it is stated that the injured persons, the 2 of them are unconscious, you said?
Yes.
That 2 of the injured persons are still in unconscious condition and getting treatment under ICU. It is also stated the rest of the injured persons have received multiple bullet injuries and that they are all in serious condition. It is also stated that the alleged accused person had submitted a copy of refill memo from gas station of Itanagar, which was issued on 26/3/2025 in support of his submission that he was not present at the site of the incident on 26/3/2025. However, it is stated by the learned counsel that the copy of refill memo could have been acquired by any person in the name of another person. Para 4. Yes. Learned counsel has also submitted that the alleged accused Sri Tagru Suraj also came to the incident spot possessing one cartouche gun and local dao. He was spotted at the place of the incident wearing police personnel uniform with his face covered by a mask, and that he is openly involved in the offense, and he has been seen by many villagers. And therefore, the plea of alibi of being in another place at the time of the incident is not true. And it is a fact that the accused person was at the spot when the incident occurred. It is also submitted by the learned counsel that because of the interim protection given by this court, the investigation has been hampered, and therefore no weapons would be seized by the IO till date. And therefore, it is prayed that the interim bail may be vacated and the present bail application may be dismissed for a free and fair investigation. Stop. Next paragraph. This court has produced the case diary and heard the learned counsels for the parties as well as the learned PP. At this stage of the investigation, this court would not like to go into the merits of the case. However, the court has to only see the observations of the IO and to see whether there is any prima facie case against the applicant. Stop. From the observations of the IO made in the letter dated 8/4/2025, written to the learned public prosecutor, this court is of the view that the IO has not made any serious objections to the present bail application, and has also observed that the investigation so far has not revealed the active role of the applicant in the present case. And it is also the view of this court that the applicant has complied with the direction of this court and has appeared before the IO on 2 different dates, and his statements have been recorded. And therefore, it cannot be said that the applicant is not cooperating with the investigation. Stop. Accordingly, next paragraph. Accordingly, the application is allowed. The interim bail granted on 1.
Your Honor, in this case, I have annexed 1 video clips also. Where the
1 what?
video clips,
Uh,
the pen drive.
You have submitted to the IO, na?
Here also.
Yeah, so the IO will do the needful, yeah. No, at this stage, it's all up to the IO, na? You cooperate to the IO, and then the alleged accused will also cooperate, and finally, the outcome may be different. What did I say? The order dated, interim order 1/4/2025 is made absolute. Stop. On the same terms and conditions. Stop. This court also imposes an additional condition that the present applicant shall not threaten or coerce the witnesses in any way and shall be available before the IO as and when he is summoned. And he shall cooperate with the investigation. Stop. This petition stands disposed. So second one will be 30.
39.
39, okay. Yeah. It's 39. In view of the, in view of the order passed in this application, the IA number, what was that? 33.
30.
IA 33, na?
30 of 25.
You check out the IA numbers later. Okay,
33.
also stands disposed. You match the IAs with the connected bail application. Then now you come.
In this
to-
case, no IA is fine.
Item 12.
Item 12, no, I have.
No IA is fine.
Then in this case, the name of the applicant will be different. Then you just delete that part where you said that IA has been filed by the victim, like that, na? Then same order. So this one also stands disposed, and then don't mention about the IA. That was 12, yeah. So now this is 13, yeah, this is 13. Then item 13, come to item 13. Item 13.
Look, in item 13, there's no IA.
Item 13 also no IA.
Here is IA.
Then item 13 also same order. Don't mention about the IA, na?
Okay. I think you're on the IA.
item number 14, 15, 16, 17.
Yes.
I made a strong
You're-
objection
you're
because they are not cooperating. And one of the victim identified the accused who fired the victim.
Who's appearing in item 14?
My lord, I am referring for that. I can put it. My, I have filed one additional affidavit in AB number 46. And then can you first page number
Wait,
30?
wait, let me get the IA also.
Uh, applicant of this item number 14 was the person whom victim identified.
And he has not appeared before the IA also.
No.
My lord, since
There is no.
bail eviction is pending before the honorable court,
No interim was made.
Oh, so no interim was given.
no entry. My lord. Since my lord, this the same matter was fixed today, so matter was fixed for hearing today.
Okay.
My lord, I have annexed page annexure 4 in my additional affidavit.
Petition affidavit in anticipatory for
Yes, sir.
16 is 46, isn't it? 46.
Yes, my lord, can you take up first 46, AB number 46. Correct, page number
Item 16, item 16.
item number 60.
Give me item 16 then. Yes,
And can you see page number?
you've served copy.
Yes.
You served the copy.
Where can you?
Yes.
Page number 34. Paragraph
Page 34.
4. Paragraph 1.
Yes.
Married. The humble deponent begged to state that he is, although the applicant number 46 and submits that on dated 26/3/2025. The applicant attended family meeting which was held at his residence at Chimpu. Along with Sri, I have mentioned the name of the family member who attended the meeting. And the same was recorded in CCTV camera installed in my residence. However, CCTV camera was not annexed while filing the anticipatory bail application number 46 of 2025. As such, this additional affidavit bring on record to CCTV footage recorded on 26/3/2025, which showing the presence of applicant at Itanagor on 26/3/2025. Madam, I have annexed the CCTV footage in detail in pen drive in page number 13. And my lord, even I have issued a certificate as mandated under section 65B of the Indian Evidence Act. My lord, on that day, I was at my residence holding a meeting, family meeting. So allegation against me with the item number 11, 12, and 13 are same. And my lord, I was also not present at the place of incident on that day. My lord, therefore, I have produced the CCTV footage.
But in this case, they're saying that you're not cooperating.
And since my lord, I am filing this anticipatory bail application.
And one of the victims has identified you.
I don't think regarding this this.
I was another one. Who's shooting? Given by the
My lord,
people.
the name of the applicant in this.
Where I left. 1 minute. PP, you had given me that loose sheet, isn't it? From the, in regard to this item 14, 15, 16, and 17, you had given me one loose sheet, na?
Yes.
Not the CD. One letter, one letter I think.
It was just status report, Lordship.
Status report, yes. 2-page. I think it went in one of the files. Oh, no, I got it. Here, what are you saying?
Fortunate. I remove the expression number today. You are hearing this point.
My lord, I have no particular query regarding item number 16.
Petition number 44. 44, right?
Yes,
Yes.
46, well, I am on
You are on 46.
46, election number 46. Because he is the meeting was held on his residence, so.
Everybody is confused because there are too many eyes and we filed it only this morning. This is in 40. This is in 40. This is IA 32. IA 32.
My lord, on same day, I was holding meeting in my residence at Chimpu at Itanawal, whereas the incident was occurred at Nomi village in Kradari district. It is more distance about 300 kilometers. Approx.
This footage should be filed in the bail application. There is no provision for filing
No, I additional affidavit. I am filing
Additional affidavit. He filed additional affidavit. He has filed the IA, but he has filed additional affidavit.
Even this should be taken from this one.
For filing additional affidavit, na? When you have filed,
This morning.
he mentioned in the morning, that's why we are allowing, to be taken on board. But you have not even mentioned, and you
My
have
lord,
not served
if-
copies.
if-
Have you served copies?
Yes. If I mention is required, this additional affidavit. Even my lord, in my application, I have made a amendment. My lord, can you see my application? At paragraph 6. May I read, my lord?
Applicant here is
Paragraph 6 of my bill application.
Yes.
Paragraph 6.
Yes. What did
Ma'am.
it say?
The applicant begs to state that as per the FIR, the alleged incident occurred at 26/3/2025 at between 8 to 9 a.m. at Yomi village, and at the relevant point of time, the applicant is staying at Itanawar attending some family meeting. The distance between the place of incident and Itanagar is about 250 kilometers. And as such, the allegation made against the present applicant is not sustainable and have no iota of truth. And while the humble applicant craved the leave of this honorable court to produce the CCTV footage of applicant recorded on 26/3/2025 during the course of hearing. My lord, I have made a environment in my eviction also. My lord, on that day, I was at Chimpu. It is not possible to move within a few minutes from Nyomi to Chimpu, my lord. I don't think the police also have any such allegation against me because I am totally innocent. I am residing in Chimpu. And they're saying that my Fortuner car was, I'm coming with Fortuner car. I have no Fortuner car.
One of the victims identified and stated that Sri Takru Daje, that's the person who fired upon him.
My this application is Takru Tame, not Taje.
Takru Tame.
Takru Tame. I am ready to cooperate the investigation. Since my eviction is pending before the honorable court. Well, since the out of same allegation.
And they have made an effort to apprehend also, but
Yes.
you are absconding.
Well, I have appearance on the therefore I have filed this application.
No, I know that.
And same is pending before the honorable court. Since my lord, I'm availing my
Takru Daje is applicant in which case? Which one?
is item number 14.
Item 14.
This is item number 16. Ma'am.
So you have moved it on 7.
Yes.
7/4.
Yes.
So that means this item 14, 15, 16 and 17, you have moved on 7/4.
Yes, sir.
Okay, this is item 16.
16.
16. Anticipatory bail application 46 of 2025. This application has been filed under section 482 of the BNSS, praying for grant of pre-arrest bail to the applicant Takru Tame, being apprehensive of arrest in connection with filing BS case number 8 of 2025. The applicant submits that on the date of the incident, alleged incident on 26/3/2025, he was at Itanagar and attending some family meeting. Stop. It is stated that as per the FIR, the alleged incident occurred on 26/3/2025 between 8 to 9 AM at Naomi Village. So the distance between the place of incident and Itanagar is about 250 kilometers. And as such, the allegation against the present applicant is prima facie not sustainable. And the allegation against the applicant is false and concocted, and his name was randomly mentioned in the FIR without any basis. Stop. Learned counsel for the petitioner slash applicant states that similarly situated persons in the same case have been granted anticipatory bail by this court, and hence it is prayed that he may be allowed pre-arrest bail on grounds of parity. Grounds of parity. Okay. So, Learned counsel, next para. Learned counsel, Shri such has filed the objection, had filed an objection application being IA 32 of 2025 on behalf of the 6 victims, praying for rejecting the present application filed by the alleged accused Dagru Tame on the ground that on 26/3/2025, 6 family members of the complainant has received serious injuries by through gun firing and assault by sticks and machetes. And therefore, the 6 victims are still in serious condition and getting treatment in the ICU at TRIMHS Naharlagun. It is submitted by the learned counsel that the alleged accused was at the spot when the incident occurred, and the plea of alibi does not hold water at this stage, as there are video clips and mobile phone pictures which show that the alleged accused person was at the spot of the incident on 26/2/2025. 26/2 or 26/3? Date of incident?
26/3/2025.
The Learned Counsel has submitted that the incriminating photos and video clips and also the statements of eyewitnesses have been given to the IO, and therefore there is prima facie case against the present applicant, and therefore prays that the bail application may be dismissed. Stop. Learned, next paragraph. Learned PP. But here in your this objection, na status report, his name is not there, saying that. um, This is, this is item 16.
None of the applicants submit.
He is Takru Tamu.
Practically, through the lordship, subject. Therefore, what number of
अच्छा अच्छा Takru Tachi, Takru Tamu. The name of informant is also Takru Tame.
Yes. My lord,
If such and such to the effect that on 26/3/2025, the below noted accused persons forcefully entered into the Nami area under Tali, the administrative circle owned by the victims. Such and such.
My lord, out of 7 incidents, there is 2 FIR and both had registered. The informant in this case is an accused person in another case.
What was the last name? Leonard PP. Praise that the application may be dismissed. Stop. Next para. Learned PP has also produced the status report submitted by the IO of the case, wherein it is stated that all the victims have been examined except one Takru Taro, who was still undergoing treatment in the ICU, and their statements have been recorded under section 183 under bracket BNSS. A lookout notice has also been addressed to all the SPs and OCs under which respective jurisdictions the accused persons have residential address, and notices have been passed to nab the accused persons involved in the instant case. Stop. It is stated by the IO that despite conducting raids at different places to nab the accused persons involved in the case, all efforts were in vain as they are evading arrest right after the commission of the offense. Stop. The requisition for technical surveillance of the phone numbers in respect of the accused persons were submitted and also obtained the same but their phone numbers are still found switched off. The IO has also engaged all available sources to locate the whereabouts of the accused person, but no clue could be found about their whereabouts. It is also stated that in the course of investigation, 6 accused persons have appeared at the police station. And on the strength of the interim bail order issued by this court, they have been arrested, interrogated, and subsequently released on bail. In course of further investigation, the IO stated that 6 numbers of licensed firearms, two numbers of .22 rifles, 2 numbers of SBBL 12 bore guns, and 1 number of .32 revolver have been seized from the possession of the alleged accused persons, namely Shri Tagru Suraj, Shri Takap Tagru, and Shri Tagru Talin, respectively, for further examination of the firearms stock. However, all the remaining named accused persons are still at large and thereby evading police arrest deliberately. Stop. The IO has also stated that the investigation is at an early stage and custodial interrogation of the accused person is necessary to unearth the larger conspiracy of the offense and to identify the actual persons who fired the guns. He also states that all efforts to you are not even responding to the calls of the IO. What happened? Your phone is switched off.
No call is received from the.
No, when you have switched off, how can you receive the calls? And all efforts to apprehend them have also proven futile. At least you should have received the calls, no? Why have you switched off your phone?
My lord,
The IO has also said that so 14, 15, 16, and 17 you're objecting, na? The IO has also stated that there is strong apprehension that if granted the pre-arrest bail, the accused person will influence witnesses and tamper with material evidence and hamper the ongoing course of investigation. Stop. Next paragraph. This court has considered the submissions of the parties and perused the status report submitted by the learned PP. It is pertinent to note that the prosecution had no objections with regard to the accused persons, had no objections with regard to the bail of alleged accused persons in bail application 38, 39, and 40 of 2025. And therefore, this court had allowed the bail applications. Stop. However, in the present case, the learned PP, the IO through the learned PP has expressed their serious objections as they have found a prima facie case against the present accused person, the present alleged accused person. Stop. On going through the status report of the IO, dated 9/4/2025, comma. This court has observed that the applicant has even switched off his phone number and he could not be contacted at all by the IO. Stop. The IO has also observed that the accused or the alleged accused in the present case is capable of influencing witnesses and tampering with material evidence. Stop. Accordingly, next paragraph, accordingly, on the basis of the observations made above, this court is of the view that the present application has not been able to make out the case for granting, present applicant has not been able to make out the case for granting pre-arrest bail in the present case. Accordingly, the petition is dismissed.
My lord,
Same order in the others also, but in one where they said this Tagru Taji, he was seen, na? That one is which one? Tagru Taji. That one is item 14. In item 14, you skip one paragraph, you give one line saying that the IO has also stated that one of the victims has identified the present applicant as being as the person who fired upon him. Okay.
my lord, if my objection is rejected, I may be able to withdraw the petition.
Withdraw.
Withdraw.
After all this.
Yes,
After wasting the court's time for half an hour.
if, allowed to withdraw my petition.
No. You have to do something alternative. Remedy is always there. The passing order, how can you withdraw?
If allow my withdraw, my lord, it will.
Not possible. You all the sorting. The other matters pass over for one week. 29. And other matters, any dates?
My lord, in item number 19, there speaks for finding the darkness by OP number 1. As the opposite party is saying that he is not going to file any darkness.
You're not going to find.
Yes.
In that you say, that is item?
19.
Item 19, you just give one line saying that the learned counsel for the respondent states that no objections will be filed. Accordingly, matter may be listed for hearing in usual course. Usual course? No fixed date, na? Just say usual course.
First week of the May.
First week of May.
Another matter is fixed on first
Okay,
week.
then listed for hearing the first week of May. No, that is after BO break. BO break is 14 to 18. First week of May. Yeah, first week of May for hearing.
And your lordship, item number 18 may be fixed after 4 weeks.
18. After
And
4 weeks.
lordship, there's an interim order.
The interim order passed earlier shall continue till the next date.
Oblige your lordship.
That's all.
Lordship, item number 28, Lordship. Lordship, kindly, this matter may be listed tomorrow, Lordship.
Tomorrow.
Yes, Lordship, yesterday we have mentioned it for listing of the matter today, Lordship.
Tomorrow.
I can
pass
cancel.
over for the day.
And
Remaining
Lordship,
cases after 3 weeks. Yes.
item number 21, Lordship.
21.
Yeah, I'm on the behalf of Khoda Yube, petitioner. Kindly the matter may be adjourned for today because council is
Only for today.
yeah.
Pass over.
No,
So
no, no.
we'll-
After 1 week because
Oh, yeah.
council is out of station now.
It is submitted.
21.
21.
21.
21.
My lord, kindly
21. 21 is already mentioned then. First week of May, we said.
sorry, 22.
21 or 22?
22, my lord.
22, yes. What happened? in
My lord,
22?
kindly my name may be reflected because I'm legal aid counsel, my lord. So I'm from on behalf of respondent.
We have a respondent
Yes, I was
number.
present.
Sole respondent.
Yes, my lord. No, we are 3 respondent.
Okay,
Uh,
so you will be for respondent.
I'm the mother, my lord. This is a maintenance CRPC 120.
No, but the respondent number will be one.
Yes.
The name of learned counsel, such and such, may be reflected as legal aid counsel for the respondent number 1.
No, my lord, I'm sorry. But the legal aid counsel was also present, my lord, because I have to show my attendance.
Oh, okay. So the name is not reflected, nah. So you want it
It's reflected, but
reflected.
since he is taking adjournment.
Okay. Learned aid, legal aid counsel, such and such is also present, nah? In item 22.
Your lordship,
Then,
item number 24 and 25. The matter will be taken after the Bihu vacation.
okay, 24 and 25 after Bihu vacation. Just say due to paucity of time, huh? After together. Item 23 also is in the first week of May.
23. I'm giving you both sides.
Then the other bill applications, remaining, because this one is a cover all item 14, 15, 17.